a horrible decision, but one that is even worse is AT&T Mobility versus Concepcion. The majority ruled that corporations can include in contracts provisions requiring that disputes go to arbitration instead of court. Now, this involves virtually everything that you do. This involves all the contracts that you would have for for utilities, for your telephone service, for your banking, credit cards. It also involves employment contracts that you would have. There's a 1925 Federal Arbitration Act which merely stated that parties to contracts can agree to arbitration if they want to. Mm-hmm. But now, of course, we have what are called contracts of adhesion, which means that if you want a cell phone, if you want a job, you have to sign a contract that you agree to send all disputes to arbitration. Mm-hmm. Now, California has a law. The federal law, by the way, says that the arbitration agreement is valid save upon such grounds as exist at law or in equity for the revocation of any contract. So the federal law says, yeah, you can agree to arbitration, and arbitration contracts are valid, but the same as any other contract is valid or not valid. California law, as the slide indicates, invalidates provisions in contracts where, for example, a phone company would require its customers to waive the opportunity to bring a class action, where disputes predictably involve small amounts of damages, and when it's alleged that the party has carried out a scheme to deliberately cheat large numbers of consumers out of individually small sums of money. So it's the classic circumstance when a class action is the only way to get a remedy. That is, let's say that the phone company decides, well, we're just going to tack on $30 to everybody's bill. That's essentially what happened here. Mm-hmm. The phone company is offering free phones, but if you sign up for the free phones, you got over $30 tacked onto your bill for sales tax. Oh, even though the phone company, the cell phone company, wasn't paying sales tax because they weren't making a sale. The sale was at zero price, so they were charging you for taxes they don't pay. That sounds familiar.
Yeah, and then the phones would probably not, assuming the tax was 10%, the phones are probably not worth $300 in the first place.
Well, in any event, what a phone company can do now, or anyone can do now, is they could simply just add a $30 charge. Oh, we just added a $30 charge, $50, $100 charge to your bill. We let people slam your bill, which the phone companies do. I mean, you see horrendous additions to your bill, like $19.99 a month for services you didn't order. Mm-hmm. Friend chat line or whatever, you didn't order it. Of course, the phone companies do that because they get a cut of the action. Mm-hmm. But under this new Supreme Court ruling, you can't do anything about it because they dramatically misinterpret, of course, federal law by saying that when the state law says that you can't, that it's an invalid contract, and that to say that you can't bring a class action if a company is cheating you out of cheating large amounts of people out of small amounts of money, mm-hmm. That somehow impairs this arbitration agreement supposedly the 1925 Arbitration Act mm-hmm. Favors. Now, as pointed out here in the slide, the Federal Arbitration Act expressly recognizes the validity of state laws pertaining to contracts, such as this California law against unconscionable contracts. Mm-hmm. But nevertheless, they throw it out. The majority, the 5-4 majority, criticized the inefficiency of class arbitration, but of course no one suggested that the class arbitration is the alternative to individual arbitration. The alternative is, of course, class action in court. Now, what's most important is what is never stated in this decision. The decision never describes what arbitration is about. Arbitration is the complete privatization of the justice system. In the justice system, that's the courts that we have. Judges are either elected, as all of them are in Oregon, or are appointed by elected officials with confirmation by the legislature. There are opportunities, there are rights to discovery where you get to force the other side to produce relevant information, even if it's harmful to the other side's case. There is a system of appeals. If you think that the trial court judge has made a mistake, then you get to appeal it to the Court of Appeals. If they've made a mistake, you get to appeal it to the state Supreme Court. So it's a very carefully worked out justice system that is a fundamental part of rights in America. Arbitration is totally different. In arbitration, your dispute is decided by an arbitrator. Well, where does this arbitrator come from? It's just a private lawyer who signs up for an arbitration panel. Typically, the arbitration process is that both sides are presented with a panel of 5 names, supposedly selected at random from a panel of persons who have signed up to be arbitrators, and you get to strike out a couple of them in order to come to the decision of the one who decides the case. Well, the consumer isn't going to know any of these people. Has no idea who to strike.
Right.
The corporation knows these people because they've seen them before and they know who has ruled in their favor before. They know who to strike. And if any arbitrator develops a reputation for ruling against the corporation just strikes them from the next time they show up on the panel. So the panels are absolutely guaranteed to rule in the vast majority of cases against the corporation. In addition, under federal law, let's say the arbitrator makes a completely wrong decision under the law. Let's say it's totally illegal to charge ratepayers for income taxes you don't pay. But the arbitrator says, well, who cares, we'll let them do it. Wrong decision, wrong on the law. Well, that's not grounds for appeal of an arbitration decision.
Oh, so no appeal.
The only grounds for appeal is if you can prove that basically that the arbitrator's decision was based on fraud. Basically, you have to prove that the arbitrator was bribed, which of course you can't prove. So, any rights that consumers have to fair treatment and to have their contracts upheld, and not only in all consumer transactions, but in employment transactions, anything you can think of, is essentially destroyed by this case. Now, the silver lining here is that this is based on a federal statute.
Okay.
Congress can just change it. Bingo.
Okay. What likelihood of that happening?
Well, that's up to our representatives in Congress. We now have a Republican majority in the House. The likelihood is that it won't be changed. However, I would point out on my last slide here, confirmation votes. I went back to see whether we would have these. These are the 5 justices who are ruling against the people in all of these cases. Would we have these 5 justices if the Democrats were in control of the legislature at the time they were confirmed? Scalia was confirmed 98-0. The Democrats voted 47-0 in favor of him. Justice Kennedy was confirmed 97-0. The Democrats had a 54-46 majority. They all voted for him. Thomas, on the other hand, was barely confirmed, 52-48. The Democrats voted against him predominantly. Roberts, who is really the ringleader of these decisions, the Democrats voted for him 22-22. And finally, Alito, the Democrats voted against him 42-4, but he was confirmed anyway, Republican majority. So
at least in a couple of these cases, they wouldn't be on the Supreme Court if the Democrats had voted no.
Had voted no, that's right.
Okay. All right,
and of course, all of these decisions are 5-4. If even one of these folks were placed on the court, it would make a difference.
Okay.
And of course, Congress, when it had overwhelming Democratic majorities in 2010, could have enlarged the court to 11 members, failed to do so.
All right. We have a minute and a half left. Really quickly, so I can get my finish done. Also, any idea what the court will be looking at in their upcoming session?
No. This is
okay.
looking at what they have already done is too depressing. I mean, I'm sure it will get worse.
I'm sure it will too. Right? Yeah. Okay. Good. So we've been talking with Dan Meek, who's a Portland attorney and citizen activist, campaigned many times for limiting campaign contributions, and so we're at the end of our program. We need to thank our crew today. Our crew today was Janet Morris, Virginia Hammond, Roger Bates, Tom Thomas, Hollis Benedict, and Joan Horton. Usually at the beginning of the show, I suggest that people should go to our websites and learn more about the Alliance for Democracy. So our website address is in Portland, afd-pdx.org. Our national website is thealliancefordemocracy.org. And I also want to let people know that the Move to Mend Portland group now has a website up also, which is movetomendpdx.org. So I invite you to take a look at that also. Thank you very much. I hope that you'll return next week.